sa, prova, 1, 2, 3, 4. Sa, prova, 1, 2, 3. Prova, 1, 2, 3, 4. Prova. Perfetto. Prova, sa, 1, 2, 3, 4, 5. Prova. Perfetto. Prova, sa.
Mi dici una cosa, ma dietro quale video si vede? Perché non è mio, quello che si vede non è mio. Io sono di questo. Ah, tanto qualcosa. Purtroppo you see different things on one screen. You must connect last speaker. Ah, okay. But you must connect this one. Ah, your presentation. The production. That's not your.
Okay, so if everyone is here, then we can start. My name is Nora Klebert. I'm in the Justice Working Party already for 8 years. Previously, I was working in the Ministry of Justice, and now I'm working in the justice field at the permanent representation of Hungary to the EU. Our panel is on data protection, and we will have 3 speakers. In sitting order, Zsuzsanna Belényesi from the European Data Protection Supervisor, Aki Hittanen, who is also, I guess, the oldest sitting member of the e-Justice Working Party of the Council from Finland. And we also have Vanna Palumbo from the Italian Data Protection Authority. As we just heard from the presentation of Mr. Buttarelli, also from the EDPS, data protection can be something that can help individuals, especially when they need to rectify false data, which was presented on the internet. But for those who are active in the e-justice field, it can also be seen somehow as a barrier. Because we just start working and then we have to realize that we need a more stable legal basis, or we want to create effective and fast services to citizens, and we want to give as much information as possible on the portal, and then we realize that it's not possible due to some rules. But I give the floor to all speakers, and then you will be able to present your questions, even provocative, even on costs, or even on data protection by design, or how a feasibility study can prove that data protection risks will be taken into account. So the speakers will speak for 15 minutes, and then you will have the opportunity to ask questions.
Good afternoon. Thank you, Nora, for the introduction, and also for raising the topic, is data protection a burden, or is it actually something useful, something that may even be considered as a success factor to e-government? And I will try to persuade you with this presentation that actually it's something useful and not just a burden to think about. But before I turn to the subject matter of my presentation, I would like to briefly introduce my organization, the European Data Protection Supervisor, and say a few words of who we are, what we do. Some of you probably know my boss, Giovanni Bottarelli, who's presented one of the keynote speeches, one of the opening speeches this morning. He's the Assistant Data Protection Supervisor, and maybe the next supervisor, because the term is now, there's going to be a new supervisor in very soon. You may also know that the EDPS, we are the European equivalent of national data protection supervisory authorities, like the Garante here in Italy. We are based in Brussels, Belgium, where many of the other European institutions are also based. Our job is to help ensure that data protection and privacy are respected at the EU level. We have 3 main tasks as an organization. First, in our supervisory role, we help ensure that EU institutions and bodies, such as the European Commission, but also other EU institutions and bodies, respect EU privacy law. In this capacity, we act like any other data protection authority. We handle complaints, issue guidance, go on inspections. Second, in our advisory capacity, we give opinions on draft EU legislation. In this respect, we have given many opinions on various interconnections of various databases, or the internal market information system, or proposals about the insolvency register. Third and finally, we also have a significant role in cooperating with other stakeholders, including them, the national data protection authorities, but also with many other stakeholders. Let me now turn to the subject matter of my presentation. In our advisory role to the European institutions, we often come across European initiatives, as I said, which aim at cooperation across borders and also exchanging data across borders. Data protection is often relevant for this project, as on many occasions, personal data are also exchanged. In this presentation, I would like to highlight a few selected issues that we encounter when advising EU institutions on e-government more broadly and more specifically on e-justice as well. Before turning to these issues, let me start by highlighting the importance of data protection in any e-government or e-justice project, sort of to respond to Nora's concern, is this a burden or is this something useful? As you know, respect for data protection is a legal obligation. You just have to comply with the law. However, respect for data protection is not only a legal obligation, but also a key element for success in any e-government project. This is because the correct application of data protection principles will significantly contribute to the reliability of data and will help ensure that the right data will be shared with the right people and that this will be done in a secure manner. Adherence to these rules, much of which are actually common sense, will contribute to gaining trust from citizens, institutions, law professionals, and businesses, including also the trust of judicial authorities in different member states that will be interacting with each other. Privacy and data protection are thus, in a sense, key success factors. It therefore makes sense to invest in them and do so as early as possible. As I said, much of data protection is common sense. The legal terminology that we data protection specialists use is sometimes sounds a bit esoteric, like terminology like data subjects, data controller, data processor, and all, but it's not really rocket science once you get through this terminology. To get things right from the data protection point of view, there are a number of reasonably simple things that are required. I would like to go through some of these things. First, there's a need for clarity and legal certainty on the scope of any e-government project. What does the project want to achieve? What personal data will be processed? But as these questions show, it makes sense for any project, not just for anything that relates to data protection. So it's not really something that is an extra burden, I would think. Secondly, and along with establishing a clear scope, it's also important to ensure that there's a solid legal ground for processing personal data. In many cases, but not always, this will require some sort of a law. In our case, at the European level, it often requires a new directive or a new regulation, which of course, we admit, can take some time, and it's quite an effort to achieve one. Next, when it comes to building the system, an important principle is what we call the principle of privacy by design. This means that privacy and data protection should be thought of from the very beginning, in the design phase of the system or project. Get into the technical solutions used and also into beyond technology, into any organizational arrangements. It is also particularly important that a careful assessment takes place before any more sensitive e-government projects are designed. For example, where national registers containing sensitive personal data are interconnected. The objective of these careful assessments, what we call privacy impact assessments or privacy and data protection impact assessments, are to see if it's permissible at all to go ahead with the project from the data protection privacy perspective, and if so, what technical and organization measures are required to ensure that personal data, so your rights as individuals, will be appropriately protected. Next, I would like to turn to the issue of allocation of tasks and responsibilities. Data protection laws impose responsibility for compliance with data protection requirements on what we call controller. The controllers, this is like one of our jargons. The controller is basically the organization, and now I quote, the natural or legal person, public authority, agency, or any other body which, and here comes the important part, alone or jointly with others, determines the purposes and means of processing of personal data. So the organization which decides why, for what purpose you process data and how you do it. In the public sector, this is normally the public body that is legally competent for the delivery of a particular service. However, in e-government, increasingly other public or private actors may be involved as well. This may lead to different arrangements for joint control, and there could be a lot of lack of clarity on who is doing what. And one of the main purposes, one of the things that are really important for us as data protection authorities is to ensure that it's clear who is doing what and who is liable if something goes wrong. In these cases of joint control and the involvement of multiple actors especially, it is thus particularly important to clearly allocate tasks and responsibilities. In systems involving several member states, there's also often a common IT infrastructure, which is often, not always, but often run by the European Commission. In this case, the Commission's role and responsibilities should also be clearly defined. Okay. Someone else spoke as well. Okay. The next issue I would like to turn to concerns the so-called purpose limitation principle. According to this principle, personal data shall be collected only for specified and explicit purposes and not further processed in a way incompatible with these purposes. Again, a long phrase, much in the style as mentioned in the morning in the French way of sort of speaking to on legal issues. But in principle, this means that you have to know for what objective, what purpose you process your data, and you have to think carefully if you want to use it for something else later on. You can sometimes use it for something else later on, but you really have to be careful whether you do it or not. So of course, when a government agency collects and processes data for one purposes, then decides to share it with another agency and use it for a different purpose, the question is, this can vary case by case. Therefore, in each project where systems are interconnected and data are shared, a thorough assessment should be made on whether these further uses are compatible or permissible. Any form of interaction between different systems should be therefore very thoroughly assessed. Just because one system is fine and the other system is fine, it doesn't mean that if you interconnect them, it will also be all right. Next, as we all know, there's no doubt that ICT infrastructure for e-government services or for e-justice requires a very high and robust level of security to ensure its availability, integrity, and confidentiality, if that's the case, on a permanent basis. This is even more so if one considers the risks and potential impact of cyber attacks. Finally, I would like to emphasize that the controller will also need to provide for the exercise of certain specific rights of the data subjects. Again, a terminology, data subject, that just means us, the individuals. First and foremost, as a precondition to allow the exercise of any rights, data subjects must know what is happening to their data. So transparency is really paramount, the first thing one can think of when putting in place the safeguards for data subjects. If individuals know what is at stake and how their data are used and how they are protected or alleged to be protected by those using it, then they will be able to exercise their other rights, such as the rights of access, to have access to data, then rights of rectification if anything is wrong with them, or erasures if it shouldn't have been processed in the first place. And they will also be able to object to the processing where appropriate. For example, when this is really unlawful or disproportionate to processing. These rights are subject only to a few fairly strict exceptions, for example, in the area of criminal law. So controllers must make sure they provide them, and then they do so in a user-friendly and accessible way. And I would like to close by emphasizing the importance of the current review of the European Data Protection Framework for e-governments. I understand that maybe some colleagues in the panel will talk more about this, and I'm happy also to answer questions about this. But just briefly, I'd like to say that, in January 2012, the European Commission presented a proposal for what they call a General Data Protection Regulation. This is to replace Directive 95/46/EC, which is a directive and which is the current backbone of the data protection framework in Europe. This proposal is now under discussion in the European Parliament and the Council. It has now almost 3 years passed since the publication of this Commission proposal, and we have great faith and hopes that the Italian presidency will continue to progress on the negotiations leading towards the adoption of this important piece of legislation. The review of the EU legal framework aims to reinforce data protection rules, make them more effective in practice, and aim to ensure greater consistency, more harmonization, that is, across the EU. A single set of rules will facilitate cross-border projects, but of course will also raise the stakes for e-government. Responsibility for the delivery of e-government services or e-justice will require very clear allocation of responsibilities strong arrangements of transparency, accountability, including data protection by design, impact assessments, and regular monitoring of performance in practice. So there's a lot on the to-do list. But there can be no doubt, I think data protection is a necessary ally for e-justice, and it will contribute to the success of any good e-justice or e-government initiative. Thank you.
Now I'm giving the floor to our colleague Aki Hitanen, who's going to... Vanna Palumbo. To Aki Hitanen, our colleague from Finland, who's going to speak about the Finnish approach of data protection, which is quite well known in some council negotiations as the negotiation on the insolvency regulation. The Scandinavian approach is very restrictive.
Thank you, Madam Chairman. I will not talk about the new proposal for the EU directive or about Google or right to oblivion or something else. So I will say in a few words about the Finnish approach to data protection, especially concerning the judiciary. Of course, basically we all have the same rules in Europe. We are all implementing the old directive concerning protection of personal data, but still, of course, there are differences in the national approaches, and of course also differences in the traditions. In Finland, we have a fairly old tradition of data protection, so it all started in 1988 when the first Personal Data File Act was established and published, and it was the first act concerning data protection in Finland. And at the same time, the so-called data protection ombudsman came into existence as a national institution as well. So the functional objective of the first act was just to promote the development of good data processing practices. And I think that was quite successfully implemented in the national administration. In 1999, after the EU Data Protection Directive came into force, there was a clear need to replace the old act in Finland as well. The main principles remained largely unchanged. The biggest change was just that it was accommodated to the directive as well. And also the basic rights and freedoms of individuals were a bit more stronger emphasized. And in 1999, we also got a new constitution in Finland, and there was a special section on the right to privacy. So everybody's private life and honor and sanctity of the home are guaranteed. And more detailed provisions are in the Personal Data Act. The scope of data protection has been getting wider and wider after 2004. So we have had two new national acts, firstly on the protection of privacy in electronic communications, dealing with emails and other things. And then act on the protection of privacy in working. It's also called Lex Nokia. So there was certain impact from the multinational company Nokia at that moment, trying to protect the innovations and patents made by the company, so that actually nobody would steal them from any emails or transfer them by email. So those were the main reasons.